Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. Always appreciated. And the StreamYard link is there for anybody that wants to join the panel. We're talking about tonight is enforcement of a bill in equity. And so I've got some information pulled up. But before we get started, I want to tell everybody, they have been telling us all along. And they've been telling us since we were little kids. And I specifically remember it from watching Schoolhouse Rock. I'm just a bill. And it tells us about the procedure in House in putting forth a bill. Now, the simplicity of it is that there are both public bills and private bills. And like I showed you yesterday, we look up some of those private bills, and there aren't too many nowadays. But when you go through that and you go back in the past, you find many different types of private bills, and it's always talking about trust and beneficiaries. Okay? And the basic public service is a public trust. There's a basic obligation. That obligation is a representation. This is the House of Representatives, who represent those that are supposed to receive the benefit. So we're going to take a look at Schoolhouse Rock, and I want everybody to pay attention to the banner across the bottom. As it states, we've got fair use. All clips are used for fair use commentary, criticism, and educational purposes. See Zada versus Klein equals 3 LLC versus Jukin Media as it relates to what we're reviewing today, private bill, procedure in the House. And the first thing we're going to look at is Schoolhouse Rock. I'm just a bill. So remember this. I don't know how many of you have even seen this in the younger generations, but this is an oldie but a goodie, and again, it's very simple, so please pay attention.
Woo, you sure gotta climb a lot of steps to get to this Capitol building here in Washington. Well, I wonder who that sad little scrap of paper is.
I'm just a bill, yes, I'm only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee, but I know I'll be a law someday. At least I hope and pray that I will, but today I am still just a bill.
Gee, Bill, you certainly have a lot of patience and courage.
Well, I got this far. When I started, I wasn't even a bill. I was just an idea. Some folks back home decided they wanted a law passed, so they called their local congressman, and he said, "You're right, there ought to be a law." Then he sat down and wrote me out and introduced me to Congress, and I became a bill. And I'll remain a bill until they decide to make me a law. I'm just a bill. Yes, I'm only a bill. And I got well, now I'm stuck in committee, and I'll sit here and wait while a few key congressmen discuss and debate whether they should let me be a law. I hope and pray that they will, but today I am still just a bill.
Listen to those congressmen arguing. Is all that discussion and debate about you?
Yeah, I'm one of the lucky ones. Most bills never even get this far. I hope they decide to report on me favorably, otherwise I may die.
Die?
Yeah, die in committee. Oh, but it looks like I'm going to live. Now I go to the House of Representatives and they vote on me.
If they vote yes, what happens?
Then I go to the Senate and the whole thing starts all over again.
Oh, no.
Oh, yes. I'm just a bill. Yes, I'm only a bill. And if they vote for me on Capitol Hill, well, then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be along. How I hope and pray that he will. But today I am still just a bill.
You mean even if the whole Congress says you should be a law, the president can still say no?
Yes, that's called a veto. If the president vetoes me, I have to go back to Congress and they vote on me again, and by that time you're so
By
old,
that
you-
time, it's very unlikely that you become a law. It's not easy to become a law, is it?
No, but how I hope and pray that I will. But today I am still just a bill.
He signed your bill. Now you're a law.
Oh, yes.
So what do you think, guys? Actually sounds kind of simple, doesn't it? Like I said, today's monetary system, money is definitely defined as negotiable instruments. And if contract makes the law, we have to remember it's the House of Representatives that oversees the commercial side of the legislation. It's the Senate that oversees the lawful side. This is the Admiralty and Maritime. And so in order to present something to the Senate, you have to draw up a contract. That contract has to first be approved by the House of Representatives. The representatives are the ones that are representing those who are supposed to receive a benefit. This says you have to learn how to write that contract so you can show them that you know what your benefit is. It's equal consideration. Well, what's your benefit? Internationally protected person? Absolutely. You get a benefit of American interest? Absolutely. You get a benefit of American citizenship as an American business for the informed use of credit? Absolutely.
Weren't they supposed to continue to add to the articles?
If it so be determined, yeah.
And they haven't added anything since what, the gold standard? They didn't even add that to the articles.
1950? What was it? Article 27 is the last one, right?
I believe so.
Article 27 reasserted national ownership of subsoil resources, which is the gold and all that. And that was 1917.
Well, I guess my point is they crank out rules and regulations every day.
Yeah. And that's what we're talking about here is their rules and regulations say that we're subject to a bill. So we receive a bill. But that bill isn't law. That's a different bill. That's the commercial aspect of an officer performing the functions of a public office. The bill they're talking about here, making it into law, is the very negotiable instrument before the contract. It is the contract. That kind of a bill in a commercial system comes as part of the contract. This bill is establishing that private law. And again, that's, let me pull it up. That's where the Gentiles who know not the law. And that's Romans 2:14, for when the Gentiles, which have not the law, do by nature the things contained in the law, these, having not the law, are a law unto themselves. So you're literally just using that First Amendment, which is the religious waiver we talked about yesterday, that the Marines that had to give a religious waiver to avoid having to take the vaccines. But of course, that gave up their duty in the Marines and military too. That's what a religious waiver is. So So that's your constitutional element that you present to the House, along with your freedom of speech to express the truth, freedom of expression of that truth as you know it, the right to assemble those words with people in Congress and petition the government for a redress because it was dressed in error.
So which has more control over you, state law or federal?
It would be federal. You're going to go through your state representatives to present it as you're the benefactor of the state as a resident, but there's a joinder with federal because it's a Department of Bureau of Consular Affairs, Department of State Affairs at the federal level for that birth registry. That's a national document, and you can use it for international customs bonding. That's the indemnification. And it's at HJR 192. It's they can't require you to pay dollar for dollar. So what do? Revelations 18:6, double it up. Your dollar is worth that much to you, but on this side, I got to double it.
Something's going on with your mic. You kind of muffled there for a sec.
Is that better?
There you go.
So, again, remember, this is a big gamble of knowing what you're saying and doing, and knowing that you're doing things right and not with an intent to defraud or anything. You're coming with equity, and equity imputes that a remedy isn't allowed with error. So,
sorry, I spilled my water.
So the next thing I've got to look at, this is Code of District of Columbia. Again, remember, the United States is located in Washington, D.C., and that's, of course, where Congress meets and all that. So the physical persons at those physical places, the White House. If the value of the property so subject to lien shall exceed the sum of $50, the proceeding to enforce such lien shall be by bill or petition in equity. So every time they're subjecting your property to a lien for a valuation of $50 or more, they're supposed to enforce such a lien by bill or petition in equity, not at law. This is your holder in due course. And the decree which you have to make, that's your deed, which shall be rendered according to the due course of proceedings in equity. You have to know that due course in equity. In order to bring equity, or in order to receive equity, you must first bring equity. Besides subjecting the thing upon which the lien was attached to sale for the satisfaction of the plaintiff's demand, shall the judge that the plaintiff recover his demand against the defendant from whom such claim is due, and may have execution therefore as at law. Problem. Shall a judge that the plaintiff recover his demand against the defendant? Again, that administrative offices of the United States, Supreme Court, Form AO430, where it plainly says the plaintiff is the debtor and the defendant is the creditor. So if you've been named the defendant, or that estate has been named as the defendant, the legal representation of some sort has been named as defendant, then there's something wrong. Give credit where credit is due. And they make a claim, but you have a superior claim in all cases. Does that make sense?
I was just thinking about my liens, because they say they got liens against me, and I'm like, wait a minute, I got a lien against the name myself. My lien should be superior. So I'm trying to just keep it in scope. Sorry.
Well, yeah, you're absolutely right. It is in scope. You've always got a superior lien. The breath of life gives you that lien. You just have to know how to use it. The next one I've got is United States district court for the District of Hawaii. And this is a 13-page document for independent family plan, an IFP, granting IFP application, denying petition to seal, and dismissing bill in equity without leave to amend. So they're dismissing the bill in equity without leave to amend. So they're giving them the opportunity to amend, saying there's something wrong with the bills in equity. So therefore, they're going to dismiss it, but you can amend it. They're denying the petition to seal it because you can't. You have to remember a petition for a bill in equity has to come with an intent to publish certain things. So you can't seal it. You can make certain information confidential and open for viewing so long as it's viewable through a direct authority. So I'm going to drop this link for everybody to read this. As a matter of just looking through it and trying to find out what the errors are. But let's look at it first. On December 9th, 2015, Plaintiff Dennis Raymond Alexio, proceedings pro se, filed the following documents. So the first error is a bill in equity is where? Is it supposed to be in a public court at law, or is it supposed to be a court of equity in private communications with your private representatives, keeping the identity of the beneficiary hidden until the outcome? And that's not to mention these people: Barack Obama, trustee, President, Commander-in-Chief, United States of America. Barack Obama is not the trustee. The better term to use there would be principal. A bill in equity, petition for declaratory relief. That should be injunction. Enforcement of trust, protections and full accounting. Bill of accounting. Bill in equity, seeking declaratory and injunctive relief and naming as defendants Barack Obama, trustee. How come they didn't go after the surety company to do a proper investigation? Defendants, a petition to seal the bill in equity. Can't. If you're going to pose this private relief law through a bill in equity, you have to be able to do a certain publication as required. If you're going to voice your freedom of expression, then you have to make an expression and let it be known. A civil cover sheet for private American national citizens, non-combatants. So they used a good term there, but private American national citizens, I don't know what the capitalizations are here. And it goes against the grain of the biblical scriptures that I would pose. So it's just a matter of his opinion versus mine. Civil cover sheet, an application to proceed in district court in form of pauperis. So here he's not recognizing and naming himself as the plaintiff, that he's actually the creditor. So he's bringing a claim as a plaintiff, saying that he's a debtor and he's in pauperis. The civil cover sheet states that the United States Constitution is a public trust and identifies plaintiff as a beneficiary and heir of that trust. So if you're the beneficiary, then how are you the defendant or a debtor? As a plaintiff, you're claiming you're a debtor, but then claiming plaintiff as the beneficiary and heir of that trust. So he did use a proper term there, heir. But of that trust, what trust? That public trust? You're not an heir of the public trust. You're an heir of the estate that encompasses and is trying to protect that estate. Are identified as trustees of the public trust. Who identified them? And of a private equity trust. Where's that established? Where is it expressed? Can anybody tell me that? That's that birth certificate bond. That's an express trust proving that there's an element of private equity available because it's only equitable itself as a document of title. Says there's a greater value there. Allegedly created by filing the plaintiff's birth certificate, document number 1, bill in equity. The bill in equity purports to provide notice to plaintiff's status as beneficiary of these trusts and seeks a declaration from this court confirming such status. So you're looking for somebody else to declare it instead of letting your yay be your yay and your nay be your nay. So anyway, what do you guys think? Am I misinterpreting it, or do you see a logical point there, viewpoint, perspective?
I mean, I see where he's trying to go. I mean, I need a lot of the backstory as to why this was the approach.
Yeah, see, I don't know a lot of that either. But again, reading this document, I found out why they denied him and everything. And that's because he really does contradict himself throughout there. And that's why we talk about the different grammars and the different jurisdictions.
Well, I contradict myself all the time too, because I'll write stuff and then find something new and like, oh shit, I wrote it one way.
Yeah, and it's good that we catch ourselves doing that.
Yeah, but the thing is there's so many contradictions in the language itself, and then they're jumping back and forth, and then they got people on different levels of understanding of what they're doing. So it's one of those. You try to follow the logic the best you can. Like I said, the thing I found is just you got to grab something and go with it, and run it till it doesn't work. And if you can't adjust it enough, then drop it, then pick something else up. I'm just trying to really figure out why is he coming at it like this, because it looks like he's coming at it commercially and legally.
Right, and that's
and
the concept here, like I said, is that with the House of Representatives, what you're actually doing is establishing a commercial contract, but only for certain indemnifications and reservations of rights. Like I said, it's an obligation to defend a suit. So you're going to indemnify yourself for improperly defending a suit because you're not qualified. And through that obligation, that's that equity imputes an intent to fulfill an obligation. So the obligation is merely to learn. Does that make sense?
See, when you say qualify, the only thing that, I mean, we listen to those monikers, and the qualification is based on the trust that you're speaking of. So if you're speaking of the public trust, there's qualifications to meet for that public trust. If you're speaking about your own individual trust, you're already qualified. So
right.
This is where I think a lot of folks get tied up in chasing language, because if you're trying to speak, then I'm a qualified representative of the public trust. Well, no, you're not. But if you want to say I'm the qualified representative for the Stephen Alvin Martin estate, well, absolutely, I am.
Right.
So that's where that's what I'm seeing is kind of jumbled in this language, is that he's attacking it in one way for the billing the public trust, but then referencing the private and putting in a bill of equity, it's like you're crossing trusts,
Right.
And when you're crossing the trust, you have certification, the other one you don't. So that I don't know. That's
When it comes to that fictional public trust, they establish that birth certificate, and remember, it's got both mom and dad's last name on there.
Yeah.
The legacy name is the surname.
Mm-hmm.
Okay, that's the estate. That's the decedent. Mom gives you the inheritance, and dad is the legacy. So that legacy claim is the estate, and then the birth certificate is evidence of the trust where you're supposed to be the bailor, the benefactor, or settlor of the estate, so you can merge it with your private trust now because it's sitting in probate in a public trust.
And that's the gray area, because in order to be a certified party, you have to be part of an administration.
Right.
So
and that's the Imperium Privatus has put the equity acts in personam. So you have to do it in contract form. Federal acts operates in personam. State operates in rem, the thing or the person. The thing is the birth certificate itself, the material thing. You got to be able to create that contract in personam. You have to understand the person and how it behaves. That birth certificate, the person in there, that's the surety. Indemnify it.
Yeah, this is where it gives me a headache.
All right, the next one I'm going to look at, this is bill, just plain out bill. A bill is a formal or public writing or declaration, so you can't seal it. You can't make a motion to seal the bill. A bill is a formal or public writing or declaration of one's claim against another. A bill may be an equitable pleading of a claim in a court of equity. So when they're sending you that bill every month, like I've said, that's a prepaid expense. And they're fine to send you that bill every month so long as you receive your benefit, equal consideration, equal return. So you get your money back, because if you didn't receive the benefit of filing a claim and having them defend that claim for you through their board because you signed away your rights, then you never receive a benefit. So they just send you another bill. It's a claim against you. At early common law, a bill in equity was analogous to a declaration in law. A bill, so when they're sending you a bill, they are acting in equity, and it's analogous to a declaration in law. What's the declaration? That you're performing the functions of public office by dealing with these bills. A bill there's somebody else's bills. You haven't presented your bill yet. A bill may also be a statement indicating that one owes a certain sum of money to another, such as an invoice or itemized list of charges. Another common definition of bill is a legislative proposal offered for debate prior to its enactment into law, such as a draft of statute before it is enacted, such as a draft of a private relief law before it is enacted. And they give you a case. Howard Jarvis taxpayer, a couple of them. Associations versus Weber, and Whiting versus Bank of United States, 1839 and 2021. The next one is equity. In law, the term equity refers to a particular set of remedies and associated procedures involved with civil law. This is where they merged equity with common law. Common law today is civil law, which is contract law. And it refers to a particular set of remedies and associated procedures in contract law, because contract law exists with equity, but equity exists without contract law. These equitable doctrines and procedures are distinguished from legal ones. While legal remedies typically involve monetary damages, equitable relief typically refers to injunctions, specific performance, or vacatur, vacator. A court will usually award equitable remedies when a legal remedy is insufficient or inadequate. For example, courts will generally award equitable relief for a claim which involves a particular or unique piece of real estate, or if the plaintiff requests specific performance. In indemnification, you can't request specific performance. The specific performance is already there, and your indemnification as a private bill of relief is for relief for failure of specific performance that's already obligated. So in other words, you can't change their law through performance of specific, requests for specific performance, because that would be a violation of their law. You can't use your law to interfere with theirs. The distinction arose in England, where there were separate courts of law and courts of equity. Following this pattern in America, some states created chancery courts in which deal only with equitable relief. In other states, the courts of common law were empowered to exercise equity jurisdiction. This is why I say today our common law, being contract law, and the way it's written, your access to equity through negotiable instruments is educating yourself on equity and contract law so you can get through there by writing your own contracts. And that's that indemnification contract. Today, separate courts of chancery have largely been abolished. At the same court that may fashion legal remedy has the power to prescribe an equitable one. Has the power to prescribe an equitable one. You have the power to prescribe an equitable one too, but you don't do it through the common law courts by entering your contracts in there. You go through the communication with Congress. Article 1, Section 8, Clause 8, my yea is my yea, my nay is my nay, and I am the authority. But you damn well better know how to coin your words or purse your lips. Expansion of equitable relief. Courts are sometimes hesitant to impose equitable relief, particularly specific performance. Again, particularly or specific performance. Whereas indemnification is not on the performance, it's on the failure of performance if they violate you. This is because equitable remedies often require the courts to monitor the remedies to make sure that the defendant complies with the court order. See, that's a court order that they would be subject to if they violate your private law through that indemnification. However, the Supreme Court has been willing to encourage the use of equitable remedies in certain areas of law. In Cigna versus Amaro, the Supreme Court held that for violations of ERISA, the aggrieved party may be entitled to obtain other appropriate equitable relief. And this is an important term here, aggrieved party. In equity, I am the aggrieved party. I'm not coming forth with any accusations. I'm coming forth with the claim that I'm not whole. I don't care why it is, but I recognize that it's due to my own fault, and this, and this will help solve that. Again, if you want equity, you must first come with equity. If you want resolution, you have to come with that resolution. If you want them to learn, you have to come with the education yourself. That way, even if it's a test and they already know, now they know you know too. And it helps enforce your position in knowing equity. Obtain other appropriate equitable relief in addition to legal remedies. In Montanville versus Board of Trustees of National Elevator Industries Health Benefit Plan, the Supreme Court narrowed the scope of equitable remedies for ERISA violations. In Montanville, the court held that a party claiming equitable relief under ERISA is limited to the relief typically available in equity. That's why it's hard to make a claim of equitable relief under other things other than that constitutional element, religious waiver. Is limited to the relief typically available in equity. As applied to ERISA, equitable relief will not extend to a plaintiff enforcing an equitable lien against the defendant's general assets. That's part of that religious waiver again. Owe no man anything. If you're going to do this, make sure you're not sitting there placing liens. You're making all parties whole. It's a different aspect. John Norton Pomeroy's A Treatise on Equity Jurisprudence, as administered in the United States of America, adapted for all the states and to the Union of legal and equitable remedies under the reformed procedure, is generally viewed as an authoritative source on equitable remedies in the United States. You guys got anything on that? You guys want me to click on any of those other definitions here? Find anything out? Remedies, civil law? Latin for it is vacated. Vacated for void. A rule or order that sets aside a judgment or annuls a proceeding. This is the injunctive relief. A rule or order that sets aside a judgment or annuls a proceeding. Article 1, Section 8, Clause 14. Again, constitutional element under Article 1, Section 8, Clause 14. Congress shall make rules for the government. They don't make rules for the private people. You guys got anything?
Well, I've vacated quite a few out of the probate case. They just keep ignoring me. So that's my curiosity.
Well, I think that's because we're presenting it to the wrong place. And I know it certainly has to do with the Health and Human Services because it has to do with the estate that's being probated. And they're the ones that are regulated by the federal government and mandated to oversee estate recoveries in every state.
See, I gave him my full redemption that I did. I did that Monday. Gave him the full redemption of everything. So, state of Missouri usually takes 3 days. That's just been my experience. So tomorrow will be the third day.
Congressional Research Service, informing the legislative debate since 1914. Private bills, procedure in the House. Updated January 5th, 2024. It's only 6 pages. This is the first page, the cover sheet. Then it's got Congressional Research, Private Bills, Procedure in the House. Summary, R45287, January 5th, 2024. Christopher M. Davis, Analyst on Congress and the Legislative Process.
I don't see what page you're talking about.
Oh, I'm sorry. My apologies. Is that better?
Yeah, that's it.
Okay. 6 pages. This is the first page. Then the second page, we got our little summary here. I just read. Private bills, procedure in the House. A private bill is one that provides benefits to specified individuals, including corporate bodies. Individuals sometimes request relief through private law when administrative or legal remedies are exhausted, but Congress seems more often to view private legislation as appropriate when no other remedy is available, and when enactment would, in a broad sense, afford equity. So, when we have 94 cases, or when we've been through 17 years of trying to get our word through that, hey, that's my estate, I need to have it fixed, they have a basic obligation of public service. Again, the true benefit is knowledge, and the first duty in law is legal notice. What would you give legal notice of anything else other than knowledge, which may be new? And that's why they call it news. It's news to you. It's new. It's what these people don't understand. They think they know the law, or they sit there and tell you, I'm just doing my job. Well, that's the problem. You think you know the law when you don't, and then you profess that you're just doing your job when you should know much more. From 1817 through 1971, most Congresses enacted hundreds of private laws. Most Congresses enacted hundreds of private laws. This is why when we went over the private laws yesterday, and I showed you there's very few in modern times. There's few years they don't have any. But since then, the number has declined significantly as Congress has expanded administrative discretion to deal with many of the situations that tended to give rise to private bills. Since 2012, 5 private laws have been enacted. Private provisions are also occasionally included in public legislation. The Senate considers private bills using the same procedures that are used to consider other legislation. So you're literally creating your own private laws. And when did that, let me see here. Let me ask, when did School of Rock come out with I'm Just a Bill? 1976. So they've been telling us for quite some time. They just changed the way it's told. They changed who tells it. They changed who discerns it. See, that's the people giving up to that comfort and convenience to let somebody else administrate that kind of discretion, when you should be the ones making that discretion yourself and coming forth and enforcing the right of private bills. Page 3 is contents, subjects of private bills, introduction of private bills, committee considerations, floor considerations, further proceedings, contacts, author information. So, it says a private bill is one that provides benefits to specified individuals, including corporate bodies. Individuals sometimes request relief through private law when administrative or legal remedies are exhausted. But Congress seems more often to view private legislation as appropriate when no other remedy is available, and when enactment, in a broad sense, would afford equity. So, does equity allow, or does the equitable legislation allow for somebody to be pulled over by one of their officers and be able to show them documentation, legislative documentation that is the law? So it wouldn't matter if they know the law or not. It is law, and now you know it. You've been given notice. That's at Article 139, armistice. The officers are not accorded to it until they're given notice. So you give them notice. That's your notice. You have to have a remedy for the first duty in law. legal notice. A different kind of identification. The individual's name and number identify the record. I need you to see me as an image and likeness and know I'm a living soul. And I have a greater truth and a greater life and a greater way. From 1817 through 1971, most Congresses enacted hundreds of private laws, but since then the number has declined significantly. This is just the same thing as what we read above. So it says, subjects of private bills. No House rule defines what bills qualify as private. But most private bills have official titles stating them to be for relief of named individuals. Remember when we went through those private relief laws, that's what it was. It was private relief law for, and then it named an individual. House Rule 12, Clause 4, prohibits the introduction or consideration of private bills for granting pensions, constructing certain bridges, correcting military or naval records, or settling claims eligible for action under the Tort Claims Act. I'm not making any claims other than an equitable claim. It's not under a Tort Claims Act at law. It's not a military or naval record. It's a legal record in the military's holding. It's a military government. So all of those records are military or naval records. Immigration, example, residency status, visa classification, judiciary. It's a judicial proceeding because it's about money. Domestic claims against the government. Foreign claims against the government. Patents and copyrights. Vessel documentation, transportation and infrastructure. Taxation, income tax liability, tariff exemptions. This is the Ways and Means Committee. And that's what it's about, is the taxation of the probated estate, and the fact that they're holding it, and their claim is they're responsible for it, so they have to maintain it, and therefore it's a cost of expense to them. Public lands, example, sales, claims, exchanges, mineral leases, natural resources. Public lands, claims. God formed man of the dust of the ground, and when he breathed the breath of life into his nostrils, man became a living soul. They're subjecting you to vessels of maritime law of the sea, rather than recognizing you as an admiral of the land, the common law of the land. Veterans benefits, veterans affairs, civil service status, oversight and reform, medical, drug approvals, HMO enrollment requirements, energy and commerce, military decorations, armed services. So these are all the things you can make a claim for, but it specifically says public lands, sales, claims, and that's the one I would use. See, they condemn the land for its commercial purpose, yet they're not supposed to buy or sell the land because it's not theirs due. So what gives them the right to condemn it? Same with man. I am not theirs. What gives them the right to condemn me? No tongue shall prosper against ye. Ye shall rise up against any judgments and condemn them. I'm not condemning the man and women. I don't hate you. Again, I reassert, it's the things we say and do to each other that I hate. That's what I'm condemning. And I'm not innocent. I'm guilty as well.
What's that expression again for the claims of, or for the for the relief of?
Right.
What?
Yeah.
How is that expressed?
um, for the relief of
Okay.
Steve Martin.
For the relief of.
Introduction of private bills. So they discuss it and they tell you private bills are introduced and referred in the same way as other measures. They are commonly introduced by the member, House of Representatives, by the member, so it's a House of Representative member, and they are commonly introduced by the member who represents the individual to be benefited. So if I'm the one that's to be benefited, I have to communicate with Congress through the House of Representatives, state representative. Residency status, visa classification. I am a man born on this land as a living soul, and I am a sojourner as a tourist across all of his lands at pleasure. I'm not conducting any business. Seldom are companion bills introduced in both chambers. House Rule 7, Clause 7 permits no co-sponsors on private bills. Committee consideration. Immigration and claims matters, public lands, have long been the most common subjects of private bills. The Committee on the Judiciary Subcommittee on Immigration Integrity, Security, and Enforcement handle private bills under established subcommittee rules. The subcommittee generally takes no action on a private bill unless its sponsor submits specified documentation and requests a hearing. If the subcommittee chooses to hold a hearing on a private bill, the sponsor is generally the only witness at such hearing. It's private. The subcommittee makes available to members' offices information on what documentation it requires and the kinds of bills on which it is likely to take favorable action. Coin your words or purse your lips. It usually declines to report a bill if its records show few precedents for favorable House action in similar cases. Panels that handle other kinds of private legislation have no similarly institutionalized procedures. Have no similarly institutionalized procedures. So the House is the only one. Floor consideration. House Rule 15, Clause 5, establishes special procedures for the consideration of private bills. When reported, private bills go on a dedicated calendar. The private calendar, House Rule 13, Clause 1, on the first Tuesday of each month. The Speaker is to direct the clerk to call the bills and resolutions that are pending on the private calendar. Each bill is called up automatically in the order in which it is reported and placed on the calendar. The bills are considered under a hybrid set of procedures known as the House, as in Committee of the Whole. Does that sound like the people? Meaning that there is no period of general debate, but debate and amendment may occur under the 5-minute rule. Usually, however, no debate occurs, and private measures are disposed of by voice vote. Disposed of is a disposition. What was the disposition? Was it approved or disapproved? At his or her discretion, the Speaker may also, on any other day of the month, call up for consideration a bill or resolution that has been pending on the private calendar for at least 7 days. Providing there has been 2 legislative days, notice to the House of an intention to do so. During the call of the private calendar, if two members object to the consideration of any bill, it is automatically recommitted. Sound like I'm just a bill? What happens if they veto? Well, I go back and I'm recommitted. Have you been committed yet? It's insane out there, folks. During a Congress, each party routinely appoints an equal number of official objectors who are responsible for examining bills on the private calendar and objecting to those they deem inappropriately. They have to have objective views. That objective view is a matter of being able to determine if what's being put out as being true and assured as a proper grant of authority. Sometimes a member of a subcommittee dealing with immigration or claims has served simultaneously as an official objector. In practice, instead of objecting, objectors may ask that a bill be passed over without prejudice, which gives sponsors an opportunity to discuss concerns with them informally before the next calendar call. That sounds like an ongoing arbitration or negotiation. So it's a developmental pattern. Again, like I said, it sounds like a path of education, gradually learning with each other as we Socratically debate over the morals and principles of what is right and wrong. And that's it. If a private bill is recommitted, the committee may re-report it as a paragraph of an omnibus private bill, which has priority for consideration under Rule 15. Instead of taking them as they come in, once you've been recommitted, now you take priority, and they'll see that first because you've been waiting longer, and it has a more hastiness or a pertinence to it to have it done and over with because it's been recommitted. At this stage, the substance of each original private bill may be defeated by majority vote by means of a motion to strike the paragraph out of the omnibus bill. Otherwise, each paragraph may be amended only by reducing amounts of money or providing limitations. And that's what we're doing with the indemnification. That's all we're really doing is providing limitations. Your performance is limited, or your liability or surety, whatever the language we end up using, is limited to the fact that you're obligated to your performance. If you fail your performance, the limitation there is that now you owe, and this is the fee schedule. This, these are the elements. That's the construction of the contract, and if they fail those contract obligations, boom, 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 boom. Your obligation as a public servant is not to harass and interfere with the benefactor. You're not supposed to be pulling me over. Unlawful traffic stops, $250,000. If you actually arrest me and take me to jail, that's kidnapping. That's going to be at least $25 million. See what I'm talking about? You have to learn how to put those contract terms and conditions in there to let them know that, hey, I'm going to indemnify you for $25 million if you happen to accidentally kidnap me. After an omnibus private bill is passed, it is broken up again into separate bills for further action. Committees seldom re-report private measures if they are recommitted, and the House does not appear to have considered an omnibus private bill in decades. Although the practice is not common, the House has sometimes considered private bills using other parliamentary mechanisms. This is just representative mechanisms, such as suspension of rules procedure or by unanimous consent. Further proceedings on private bills follow the general lawmaking process. So as long as you're just negotiating and you're going, it may take a period of time. One guy might get it right on spot and get his pass through right away. The next guy might take a few years. Depends on how we're coming together with this information and helping each other out. The more we do this, the more we'll be able to work with the House of Representatives, communicating with Congress like we're supposed to, as the oversight of education. That's it. Not enforcing anything else, but merely the education, and the education spreading itself will help enforce the morals and ethics that they're bound to, in my opinion. Presidents have vetoed private bills, sometimes by pocket veto. Otherwise, Congress may override the veto in the same way as with public measures. Either House of Congress may also, by resolution, refer a private claims bill to the Court of Claims for a recommendation from a trial commissioner. This is a trial balance. This is where they're going to check with that ledger and do a trial balance. Is it worth it to keep stalling this guy, or does he know enough that it might cost us? These recommendations are requested occasionally and are strictly advisory, but they are often followed when requested. And it gives the author information, acknowledgments, and disclaimer. This document was prepared by the Congressional Research Service, serves as nonpartisan shared staff to congressional committees and members of Congress. It operates solely at the behest of and under the direction of Congress. Information in a CRS report should not be relied upon for purposes other than public understanding of information that has been provided by CRS to members of Congress in connection with CRS institutional role. CRS reports as a work of the United States government are not subject to copyright protection in the United States. Any CRS report may be reproduced and distributed in its entirety without permission from CRS. However, as a CRS report may include copyrighted images or material from a third party, you may need to obtain the permission of the copyright holder if you wish to copyright or otherwise use copyrighted material. So it's telling us there are procedures. Oops, we lost Steve. Let me drop the link in case he's still down there, wants to join. I know he gets a headache from a lot of this stuff. I go too fast for him sometimes. My apologies. You still with me, Mitchell?
Yep.
Awesome.
Yep.
Awesome.
I'm following too. I've had a long day, but I really appreciate what you're doing. For me, it's really pulling it together. So I'm working on building my portfolio of evidence, and something that I'm really missing is, that fee schedule, which you just kind of touched on a bit ago, and I think you're really critically and effectively communicating what we need to be able to do to be able to enforce that, to be able to assert ourselves appropriately, which will, really encourage them, if not, sort of force them, because there's going to be severe consequences to do their part, and
Yeah, and that's what we've got to realize. Our part in it is so critical when it relates to that oversight. And that is, like I said, when we're drawing this stuff up, it's a matter of our education and freedom of speech and freedom of expression through our observances, firsthand experiences. But the ultimate and more superior right is of all those other people out there that have a right to know this stuff. That's what enforces our right to freely speak and express ourselves. So they go hand in hand, and we have to learn how to start working together. In that, this is that Article 1, Section 8, Clause 8. This is that other constitutional element. These are great constitutional points to bring up as that constitutional element in a bill of equity before the House, and that is that Congress shall have the power, and Clause 8 says, to promote the progress of science and useful arts, such as literal arts, language arts, literature, That's the Treaty of Berne. There's already a protection order for literary and artistic works. Article 1, Section 8, Clause 8 mimics it. Image and likeness. That's a protected work. They're mimicking the scriptures. How do you copyright an image and likeness of the very creator? By securing for limited times to authors and inventors the exclusive right. That's the exclusive jurisdiction. Equal station of the other exclusive jurisdiction, the Postal Service, to their respective writings and discoveries. The Intellectual Property Clause empowers Congress to grant, assure, authors and investors exclusive rights in their writings and discoveries for limited times. Again, there's that limited times. I've spoken about Samuel Clemens, Mark Twain, and Tom Sawyer, and how he had certain of his writings being taken advantage of by Canada and the import-export rules and stuff, and the fact that his artwork, his literature, worked in or arrived in Canada under a contract agreement and publication prior to arriving in the United States. At that time, Canada had agreements with the United States for import-export laws, and they just simply bypassed them and took all, and bought an excessively large amount of his works and then sold it themselves for profit to the United States before his work hit the United States. So he lost out on the profit. The limited period of time goes to the estate that's passed on to the heirs that we were talking about earlier. He went before Congress. He communicated with Congress for private relief law, a public relief law for authors and their works, so they could pass on that intended value to their heirs before the public came in like vultures and destroyed it all. How is he going to be able to pass on the value to his heirs if they bypass import-export laws that cut him out of his profit? That's what we're talking about, is equity. So it's all correlative, and it's a matter of comprehending, again, that I'm just a bill. It's been telling us a long time, and it is pretty simple, and it's just a matter of getting out of that public education system that's indoctrinating us to remember the bullshit and not think for ourselves. Be diverse. Be artful. Express our talents. That's the money of our Lord. That's what he wants us to do.
And it's okay to make mistakes, because as long as we're operating in good faith, operating may not be the appropriate terminology, but you know what I'm saying.
Yeah.
It's okay to make mistakes. We can correct the record and move on.
Well, I think that's another one of those things that I understand about this system that's so beautiful, is that we have a system today that allows us to comprehend that at the most basic level. For crying out loud, people, they call it negotiable instruments. Learn how to negotiate. I'm sorry. No, I'm sorry. You go first. No, you go first. Remember the chipmunks? Great at negotiation by letting each other know that they recognize they're both fallible and they're not perfect. They've been telling us through cartoons all our fucking lives. So anyway, that brings us to the end. What do you got for us, Mitch? You're mute. You're muted.
Oh, not much, man. Thank you for what you do. Thanks for being you. If you don't mind, I'd like to take a moment of your time in private, but no worries if not.
All right. Yeah, I'll just hang out. I'll be back as soon as we're done. All right. And with that, you guys know me. I appreciate all your support. Please hit the like, share, and subscribe button for me real quick. There's a PayPal link for anybody that wants to share some love. Always appreciated. And of course, I love you, but I don't give a rat's ass whether you love me back. I say I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see everybody tomorrow. Bye now.
Where's the 8? Come on.